Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about life sentences. People convicted of murder are eligible for parole after 25 years. But what if someone murders more than one person at the same time? Should they be sentenced to serve 25 years back to back, or can they serve those sentences simultaneously? In 2011, the Harper government introduced sentencing provisions that allowed for consecutive or stacked life sentences. On one hand, it seems unfair that someone could get what some view as a discount on murder. On the other hand, if sentences are imposed back to back, someone could be ineligible for parole for over 100 years or more. It exceeds any possible lifespan. Is this disproportionate? The Supreme Court will be considering this very question in the coming months in an appeal in a case called R. and Bissonnette, the Quebec City mosque shooter, who pled guilty to 6 counts of murder and 6 counts of attempted murder. The Quebec Court of Appeal reduced his original sentence of life without parole from 40 years to 25 years. What's the basis for this decision, and what's going to be argued at the Supreme Court? Here today to discuss this are 3 legal experts: criminal lawyer Ari Goldkind, Professor David Millward, and Professor Lisa Ann Silver. Thank you all so much for joining me today. Now, I want to start with this Bissonnette case, which is one a lot of our viewers are familiar with. Mr. Bissonnette was originally sentenced 40 years for these 6 murders, and it was reduced to 25 years at the Court of Appeal. Professor Silver, can you explain why the Quebec Court of Appeal reduced that sentence?
Sure. So first, I want to make it clear that it is a life sentence, right? You're not stacking the life sentence. What the stacking involves is when they're eligible for parole. So the best way to explain what the court did is to look at the court's judgment. And what they said in their very first paragraph is they said that the judgment wasn't about the horror of the actions or the impact of the crimes on the community, but it was first and foremost about the constitutionality of a provision of the criminal code, which is section 745.51. Now, when a law is inconsistent with the provisions of our charter, then that law cannot stand, and that was the finding here. And that was the finding of the trial judge as well, and the Court of Appeal. So they both agreed that the law was unconstitutional. What they differed in is the remedy, or how to fix that inconsistency. So the trial judge decided to read into that section and to effectively cure the inconsistency by giving a judge a discretion in the parole ineligibility periods so that the judge had more options and didn't have to just stack 25 on top of each other, 25 being the mandatory sentence for first-degree murder. And so what the judge did was say, well, I can read into this and I can impose less or more depending on the circumstances. And that's how the trial judge came to that 40 years. But the Quebec Court of Appeal disagreed. They didn't agree that that was the appropriate remedy. And instead, they simply struck down that law. And what was left, therefore, was really the sentencing approach from 2011, which mandated the imposition of a mandatory life sentence with no parole for 25 years without an ability to stack those parole ineligibility periods. So the sentence imposed was simply the only one available.
So there's an excellent explanation of some of the nuances of the case. Now, Ari, you've said that this case isn't as nuanced as some people think it is. You think it's pretty straightforward. So what do you think this case is about?
Well, there's legal nuance, and Professor Silver explained those nuances perfectly. There's reading in, there's reading down, there's charter arguments, there's what's grossly disproportionate. But at the core of this, the average person can really understand this. And the Quebec Court of Appeal says some things and mimics the trial judge that I would think would make the ordinary, average, reasonable, correct-thinking Canadian go apoplectic. This is really a case about whose life matters more. You'll notice my use of the term matters because that's been a pretty important term in the last 20 years. And what the Quebec Court of Appeal decided, in my view, and they did it in a legally understandable way. It's done in a very clever way. It's done in a way that follows cases before, as they've said, look, Bissonnette's young life matters more than the victims he mowed down in that mosque. And we forget, by the way, he mowed down a bunch of people that didn't die. There were multiple counts of attempted murder, including children. And so what the Quebec Court of Appeal very much said is, look, it would be cruel to not give Bissonnette an opportunity when he's 60, 50,
Ari, we've got
80.
to go to commercial, but I'll let you finish when we get back.
Absolutely.
Welcome back to Canadian Justice, where we're talking about consecutive or stacking of life sentences. Ari, you were talking about what you think this case is really about. I wanted to give you an opportunity to finish that thought.
Yeah, and it's much more interesting than the legalese of it, Christine. What the Quebec Court of Appeal said, again, using some of the language from the trial judges, in a free and democratic society, let's use those words, free and democratic, us three judges are going to strike down what Parliament, duly elected, again, we can't use the name Harper because it's sort of like Voldemort, but what they decided in 2011, we three are going to say is cruel and unusual to a young man like Bissonnette, who only committed this crime in 2 minutes. He's not a serial killer, he's not a hitman. And Christine, here's the language that I think people need to know. They said, and they adopted the trial judge that said Canadians would consider abhorrent and intolerable any sentence denying Bissonnette a reasonable prospect of release on parole in the last years of his life. I wonder how many ordinary average Canadians were polled on that.
Professor Millward, I want to turn to you because one of the things we've been talking about is what is cruel and unusual, and the court's going to be looking at that in this case. So can you explain to our viewers what cruel and unusual means and where it's protected in our charter, the prevention of cruel and unusual punishment?
Okay, so there are certain things that the right against cruel and unusual punishment prohibits. One is corporal punishment, like caning. Another one is the death sentence. Now, there is also a theme that's been picking up in recent years, and that is the grossly disproportionate sentence, where a sentence is too long, accounting for the accused's personal circumstance and the extent of the harm he did, and numerous other factors. And this has come up quite frequently in cases involving mandatory minimums. Now, the way that courts look at this is if there's reasonable hypothetical, there's a certain kind of scenario where you can actually expect it to come up with a certain amount of frequency. And judges may, for that reasonable hypothetical, might want to go with something like a conditional sentence or prioritize rehabilitation. But the mandatory minimum removes that judicial discretion. It doesn't give the judge any room. It's in that kind of situation where courts have frequently been willing to invoke the charter right against cruel and unusual punishment and strike down mandatory minimum laws. The problem that I see here with the Bissonnette case is that the provision that my colleagues, Ms. Silver, indicated is entirely discretion-based. So the provision itself says the jury doesn't have to make a recommendation about whether to stack sentences or not, but they can. And even if the jury does make a recommendation, the judge can take that recommendation into account, but it's up to judicial discretion about whether to actually stack sentences or not. So just to anticipate the Supreme Court, there's a part of me that thinks that the Quebec Court of Appeal judgment stands on pretty shaky ground once it's going to come to the Supreme Court. And then the Supreme Court might surprise us, but that's my initial hunch.
And we actually, on these mandatory minimums, we did a show a few weeks ago about that very topic. So I'd encourage anyone who's interested to check out that episode, which was also great. Professor Silver, I want to turn to you about something Mr. Goldkin has raised. So every human life has infinite and incalculable value. So does letting a killer, a convicted killer, serve one prison sentence for ending multiple lives, does that remove some moral culpability?
Well, first, let me say that there's no question that every life that is taken matters. And as you say, you can't put a value on a life. And that tends to be the criticism with this law, that it does attempt to put a numeric value on the life. And the other criticism that is reflected in the Court of Appeal decision is that these consecutive parole and eligibility provisions, because they stack, 25, 50, 75, 100, 150, cannot fulfill this government's objective that this law is to count every life that is lost. So that's been part of the criticisms, although I have to say the Alberta Court of Appeal has no problem with the stacking of parole and ineligibilities, and certainly doesn't buy into those arguments. But as to your question about blameworthiness, it doesn't remove moral culpability, it's there. The conviction is there. That is the blameworthiness part of the elements of those crimes have been found, and a sentence is imposed. But I think there's a more serious problem and a more serious question, which is, does this kind of sentence promote an offender's sense of responsibility? Does it sufficiently denounce the conduct? So to me,
Professor Silver, we've got to go to commercial, but I'll let you finish when we come back. Welcome back to Canadian Justice, where we're talking about consecutive life sentences and whether sentences can essentially be stacked or if they can be served simultaneously. Professor Millward, how many people have actually been given consecutive life sentences since this law was changed in 2011?
Not many. I suspect you could count them on both hands, to be quite honest.
And what is going to happen to them if this law is struck down? Will their sentences be amended?
I suspect that at the very least, they're going to appeal or seek some sort of process to bring down their period of parole ineligibility. Because frankly, the life incarceration, this prospect of spending the rest of your life in prison, there's a window to actually get out. Pretty much anybody in that situation is going to get out. I mean, even partial defenses where you can reduce murder to manslaughter, people go to trial just on that basis alone, just for the prospect of getting out while they still have something called life.
Mm-hmm. So, Mr. Goldkind, I want to turn to you. One of the things that the Supreme Court is going to be looking at is Section 7, whether this law infringes life, liberty, and security of person in a way that's inconsistent with the principles of fundamental justice. So, obviously, any term of imprisonment engages your liberty rights. But in this case, what they're going to be looking at is whether it's being denied in a way that's inconsistent with fundamental justice. Can you explain what that means?
The court essentially quibbles towards the end of the judgment. It's in the last 10 pages or so with the notions of hope not being a component of fundamental justice, hope being the plain, ordinary meaning. He has a hope to get out. There are good reasons that people should have some hope. It keeps the jails arguably safer. They don't look like San Quentin and every show you watch in the United States where every inmate who knows they're never getting out shanks the other. The court then talks about, really, when it comes to fundamental justice, gross disproportionality. In other words, Parliament should have said, this is sort of what the Court of Appeal intimates, if you don't want a guy to ever have the chance to get out, don't start saying you have life with no chance of parole for 672 years. Just say it. And when it comes to gross proportionality, that's where the Court of Appeal, I think, and I go back to Professor Millward's point, and which was a really important point, the courts are not dictated or commanded to stack this. It gives judges discretion. It's such a bizarre decision, even when they get into fundamental justice, which is, look, duly elected, democratically elected members of Parliament did this in Parliament. That we set aside. We overtake that discretion. Then you have judges, and Professor Miller made this point quite eloquently, who are not told they have to do this. They're told they can, and they must give reasons. So for fundamental justice to be used in the way towards the end of the decision that it is, I just don't think holds to great water, and I think would offend the normal average sensibilities of most Canadians when we tend to forget in fundamental justice, some people in that mosque had a right to still be alive.
Professor Silver, I want to give you a chance to respond to that because Mr. Goldkind mentioned a number of points that you brought up, and I want to give you a chance to respond.
Well, I mean, I totally agree. I mean, it is discretionary. And in fact, sentencing represents a constellation, so a whole bunch of different sentencing principles and objectives, including that a judge is supposed to look at the circumstances of the case and the background of the offender. Section 745.51 does that. When you look at it, when the court decides whether to stack those parole ineligibilities, it says the judge is to have regard to the character of the offender and the nature and circumstances of the offense. So there are many factors and objectives that go along with this, and certainly 745.51 is not a mandatory minimum, as we conceive as a mandatory minimum in that sense.
Professor Millward, we have about a minute, but one of the things that the case has brought up is the debate around the purpose of sentencing. Is it to rehabilitate, in which case a sentence over someone's lifespan won't achieve anything? Is it deterrence? Is it punishment? Is it recognition of the value of the life lost? About 40 seconds, how do you respond to that?
It could be any in a given case, but in this case, I think there's something to be said for denunciation, just saying this was just plain wrong, especially when it's a hate-based crime. And people do have some concerns about whether not allowing the stacking or not allowing the stacking devalues the lives of the people whose lives are taken in the mosque.
Yeah, absolutely. And to remind our viewers, we're talking about some of the most horrific crimes of mass murders, of people just killing a person who walked into a mosque and shot multiple people, killed 6 people, wounded 6, attempted to murder 6 others. When we're back from this commercial break, we'll talk about this more. Welcome back to Canadian Justice, where we're discussing whether or not the court can sentence someone who kills multiple people to multiple life sentences served back to back. Mr. Goldkind, what are victims groups or victims saying about cases like this? Are they in favor of stacking these sentences, or do they have a view on whether they can be served simultaneously?
Well, I think getting into that conversation about stacking with victims groups just ignores the real point. Let's go back to Professor Silver's point about whether every life matters or not. You could not get a clear answer from the Quebec Court of Appeal and the trial judge that not every life matters. It is a fiction. It is a piece of imagination that every life matters if you get the same parole and eligibility for one life mowed down that you do for 7 lives mowed down. Sit down with a victims group and get them to understand that. They're justifiably apoplectic. Again, going back to our earlier points, because judges don't have to do this. They look, to quote somebody in the segment before me, the constellation of factors. And let's just point to the audience who are not needing to know how the sausage is made, what the Court of Appeal says about this law, which is it's an attack on human dignity. The provision is absurd. It would cause Bissonnette undue stress to remain in jail. Imagine sitting down with people mowed down in a mosque, a synagogue, a shopping mall. Take religion out of it and explain how there's an obsession with the offender's rights when he's taken this many lives in a country, by the way, Christine, that values at the top of the criminal code food chain murder and life. It's just something very, very vexing that if we can't save it for the worst of the worst, what are our values as a country?
So there was forceful language in this decision. The Court of Appeal used words like, they called sentences like this absurd or evil or degrading, that it was an expression of a vengeful spirit and has no place in a civilized system. Professor Millward, what are your thoughts on the use of that language in the decision?
First of all, we might have to make a little allowance for that. The decision was initially in French and translated in English, so we don't know how well of a translation that actually is. But if that language actually is an accurate translation, I would have some concerns because judges are supposed to maintain a certain professional distance to apply the law objectively. And to invoke that kind of language on some level suggests some level of personal investment in matters that is perhaps not entirely consistent with the proper exercise of the judicial office.
Professor Silver, same question to you, that really forceful language. I'm sure it was jarring for some people, especially victims, when we're talking about serial killers here. When you talk about evil, it's the mass murder. So what do you think of this language in the decision?
Well, I don't disagree with what David has already said, but I do want to point out that this was in the context of cruel and unusual punishment. So what we have to appreciate is that the court is starting with that premise, right? If they're going to start with the premise that this sentence these provisions are cruel and unusual. You already have cruel, you do see the case law on that using some very strong language about these, overly harsh, overbroad, and disproportionate sentences. To me, the real question is it cruel and unusual? And I think that is what we need to focus on, which is the Court of Appeal right when they said this? And because it may be that their language is flowing from their own perspective that they started with.
And certainly it's going to be something that now the Supreme Court is going to be looking at. When is this case being heard, Professor Silver?
I think only leave I'm not sure when it is.
But it's soon. It received leave.
Yeah.
Yeah, so
I don't know when.
It should be sometime soon, and when it is, we'll be sure to follow up. I want to thank you all for coming on today and sharing your insight about this important case and about this important topic. We've heard today the arguments about whether killers convicted of murdering multiple people should be sent to prison to serve life sentences back to back, or if they can serve those sentences simultaneously. These are difficult questions, and they go to the core of what we think the purpose of incarceration is. Do we send people to prison to punish them, to rehabilitate them, to give peace to the victims and their families, or to deter others? How you answer this question will likely answer the question of whether you think killers should be given consecutive life sentences. And it will also likely be colored by the fact that these are some of the worst crimes in our country's history. We'll soon have this question argued at the Supreme Court, and when it is, we'll be sure to follow up to have a closer look at what arguments are being made. Until then, you be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.